We certainly can. So, Gary held counsel to the board, and I circulated a handout to all of you, so you should have it and follow along. And
Yeah.
certainly, if there are questions after, you can contact staff or me for clarification. And of course, the overriding policy is when in doubt, contact the city attorney's office. Because ethics is an important area, and you don't really want to be put in the position of having violated something where you could get advice
Exactly.
beforehand and clarify whether something can happen or not. So, and I don't recall exactly who was here, but we did this last year, so this is sort of like a refresher. I don't
Does
actually-
this take the place of the 2-hour or 3-hour?
No.
Okay.
No, we
Gotcha.
still have to do that.
Super. Can't wait.
Do you know when that is? Just context.
No.
Okay, that's fine.
No, but it's been a while since I went to a training, per se.
So I think it's every 2 years.
Because the last time, well, it's been a while.
So maybe staff can follow up
Okay.
on
Yeah.
that and check and see whether.
Because the
board
last time
members-
After
I went
the
to
election,
a real
I
training
believe after the
outside
election,
was
there
like
will be
Yeah,
a
we
broad
went
sweeping
to
one for everybody.
Miami
If
Lakes.
I remember correctly, the last one I went was when Smith Joseph won his second election. So I believe after the election, they generally put everyone through it.
Okay, so going right into it, the first topic is Florida Sunshine Law. This deals with conversations with other board members
I don't talk to them.
on the same board that you are. And generally, the rule is you should be having conversations on matters that foreseeably will come before the board only at advertised board meetings. On the record, sometimes, and I don't see it here, but sometimes board members may have a private conversation on the dais, and that's something that is also prohibited by the Sunshine Law. And I've actually had experience where I've seen investigations by the Miami-Dade County Commission on Ethics on a complaint that two board members were having a private conversation
Yeah.
at another city. So it's something that you should be wary of. And, you know, if a new board member comes on and they're not aware and they start having a conversation, just say, well, we're not supposed to be doing that.
Yes.
So the summary handout identifies certain situations that people can be in where conversations could happen that could create an issue. One of them, on the second page, is where the paragraph talks about a case of interest, where a citizen was talking to various board members and sort of being used as an intermediary, but not by the board members. The citizen himself was talking to board members, collecting information and sharing them with other board members. And the state attorney started prosecuting the citizen, and the court said, no, the citizen was just engaged in lobbying. It was the board members that had liability under the Sunshine Law. So need to be careful on the kinds of things that people are saying to you. They're not supposed to be telling you what they know about other people, how they've decided to vote on the matter that could be coming before the board, or a position that another board member may be taking on an
That's an
application.
interesting question.
Yes.
That comes up quite frequently. As a resident, you have the freedom to speak to council members
Mhm.
who are about the same topic. How can you avoid, if you're speaking about the same topic that they plan to vote on? I've been in that position as a resident,
Right, so
but I don't feel
if
the
you, let's say you talk to council member A or another board member on another board, and you're making a presentation on your point of view on an application, the citizen should not be going to another board member. You can go to another board member, make a similar presentation, but don't say, well, I know
Oh,
that
I
council
see.
member A is gonna vote
Yeah.
against it, and I think you should too. That kind of thing.
because they can get in trouble with ethics for hearing that.
It's, yeah, the
It's on
use of
them.
an intermediary
Right.
is something that's prohibited by the Sunshine Law. So the
Yeah.
citizen becomes an intermediary without liability. At least that's what one
Which
court
happens
said.
a lot in
There-
lobbying.
This is not
Yeah.
a
Interesting.
district court of appeal, so it doesn't have the effect of being a statewide law. But it's something that a court did that you guys should be aware of, that creates an issue. So in the middle of page 2, I've identified some other settings: social function, seminars or lectures, community forums, and generally, you should not be using any of those settings as an opportunity to engage in a conversation about something that could foreseeably come before the board. So the candidates' night and the civic club setting, they are permitting statements of position as long as you don't have a conversation. It doesn't turn into a dialogue between board members.
Oh.
Okay, so moving on. One of the things that is interesting is the site visit. And sometimes you want to go to a site on an application that's coming for the board, and you either happen to know or by accident another board member shows up at the same time. The prudent thing to do is to not go together on that site visit. There's a difference in how courts are viewing boards, whether they have an advisory role or a final decision-making position. And since you're a Board of Adjustment and generally have final decision-making position except by appeal, you would not be able to engage in fact-finding with other board members. Okay, so the better rule is just say whoever's there first, go through it, and the other board members should wait a few minutes. Are there any questions on Sunshine Law? Okay, so the next is Public Records Law. It starts on page 4. So generally, most everything is a public record. The only thing that is significant to you are personal notes that you might take during a board meeting or make in anticipation of a board meeting. If that's not intended to perpetuate knowledge for the purpose of the city, but just to help you as an aid, as a temporary note, then it does not become a public record. And it really is only going to come up if there's a public records request made to the city. If it's made to you directly, you should refer to the city, and the city attorney's office and staff will help you through it. But it's important to know on public records, it's sort of like Sunshine. You shouldn't be using documents to share information with other board members.
So if I do my research, it's for me and not to
Yeah.
pass it out.
Yes. Okay, bottom of page 4 talks about quasi-judicial versus legislative decisions. Most of your work is going to be quasi-judicial, which gives a heightened requirement for due process procedures. And most of that means notice and opportunity to be heard. Notice is done by staff. Opportunity to be heard is by the board and through the chair. Giving people time to speak is important. And just exercise that, sparingly. The city, Jennifer, has adopted a reasonable opportunity to be heard provision. I don't recall, I didn't look back at that, but I think as a matter of state law, every city was supposed to adopt a requirement that applies to all hearings and sets the standard for how you treat citizens who are coming.
Yeah, we did that
No, I
a
think
few
we
years
have
back
that.
when
Right,
the statute
right.
was in.
It's part of
Okay.
our official thing. I remember years back that they developed it.
So, bottom of page 6, and sort of just, in connection with the quasi-judicial procedures, there's the issue of ex parte communications. That's when people come to talk to you outside of a public hearing. You're not obligated to speak to anybody just because you're a person is entitled to under the law, you're allowed to say no and say you just want to hear an item at the hearing. But if you do talk to somebody, the,
Disclose.
the way the legislature and the courts are dealing with this is there has to be a disclosure of the identity of the person and general subject matter of what was discussed. Those requirements are laid out in the middle of page 7, pursuant to ordinance, which is what satisfies an alleged due process violation, having that ex parte contact. Also, if you're getting emails from citizens, that's a form of an ex parte contact, and those emails should be forwarded to staff. They would make it a part of the file on a particular matter, and that would satisfy the disclosure requirement.
So if
Are
we,
I'm sorry, are
Yeah,
our
so-
emails public
no, but
Usually
if,
they got it.
if somebody emails me on my
to the resident?
private
They know it?
email,
Yes,
then I should forward that email
To
to staff.
yes, and they should make it part of the file.
Yes, because
Okay.
that could be pulled as.
Okay.
Interesting.
All right?
Wouldn't it be more in line with these for board members to have email addresses that are like Board of
Official.
Adjustment ones, so that anybody who is sending it, those emails get caught on the server, as opposed to just trusting that we're gonna forward you our private emails?
Theoretically, but it may be something that staff needs to review
Yeah,
and discuss
I know
with
with
IT.
the charter board, we have to send an email to a made-up charter board email that captures any emails so that it keeps everything separated.
Right, maybe they would create an email for that purpose.
Just
I
saying
mean,
that
I
would
could
be a
forward
lot
it.
more,
Forward
Prudent.
emails too.
Yeah.
Like BOA
yeah,
At,
emails at North Miami
yeah.
FL.gov or something.
that's a good idea.
That would make compliance a lot
It's
easier.
achievable.
Yeah, okay.
We'll bring it up.
So the next two items are things that are personal to you, the conflicts of interest, and I'll include gifts in this discussion.
Gifts.
So on both of these are things that, you know, you just need to be aware of, to comply with. Generally on conflicts, the most important one is if you see an application that is in the vicinity of your personal home or business, you need to be aware that that could create a conflict issue. And you either should discuss it with staff, or city attorney's office, or me to see whether there's such a small number of affected persons that there's a rule called the special private gain or loss rule that deals with how many people are affected and the nature of the interest that you have that would be affected. So that's just something that needs to be reviewed to make sure that you're not voting on a matter in which you might have a conflict.
It's called the special gain or loss provision.
Yes.
And that, does that specify how far away and what the radius?
So it's really the number of interests that are involved, and so
Okay.
assuming, for example, like the house that was, the variance for the rear setback, if there were only 100 homes in that neighborhood, or less than 100 known homes in that neighborhood, and one of the board members had a
Live-
house in that neighborhood, there might be an issue as to whether you were affected differently than other people in the city. So staff would need to do the analysis of how many homes there were and whether, you know, whether you were a landlord or, and what the effect of granting that variance would have, in consultation with the city attorney's office.
Okay.
So okay. Gifts, there are disclosure requirements. Hopefully, you know, the simple rule is you don't accept any gifts in connection with your work. Surprisingly, though, there are situations where you might be receiving gifts from people who are doing business with the city just by virtue of them knowing you. You're having a wedding or some other occasion, and you're inviting people from the city who are doing business with the city, or an applicant or somebody. And it's just something to be aware of, and also consult with staff on the effect of that. I remember our planning director in Miami Beach was getting married, and he had to do gift disclosures for all the people that he was inviting, who were applicants or representing applicants before the city. So it's just something to be aware of. And the last thing is the Kuntz case and the question of unconstitutional conditions. It's not something that these city boards do a lot of, but you need to be aware that sometimes if you want to impose a condition that requires an applicant to make an improvement off-site or even on-site, that there are certain limitations to that. They have to be related to the nature of the use on the property and the extent of the impacts that that use is causing. We can have more detailed discussions if that ever comes up, but it's just something you need to be aware of.
Okay.
And that's it, the speedy version.
Good.
Thank you.
Thank you.
Okay.
And
You
Derek-
gotta,
Derek has the
Of course.
presentation there.
Is the other one on here, do you know? Is it up?
Dunya can help.
M5?
F,
F5.
F5. Yeah, you're like me.
So, in addition to what Mr. Hill went over, we also want to talk about the provisions within the LDR that we need to make you a little aware of. So, to authorize, accept as provided by, in section 3-606, variance. So what we are talking about is your powers and duties, what you have to do. So you have the authority to, as we had tonight, a variance that you authorized. You have the authorization to do exceptions and to hear and decide on variances as we always stated. Okay, we have a seven-member board with 2 alternates, a minimum of 5 members to speak to what the citizen spoke of tonight, that to have quorum, that is regulated by the land development regulations. Without a text amendment, we cannot deviate from that requirement. Staff is your assistance to, and that's from the Community Planning and Development Department. You meet, as you know, every Wednesday, third Wednesday at 6:30 p.m. here in the City Council member. Your quasi-judicial board, as was stated, so you render final decisions. You must be a resident and hold no other elected office or be a city employee. No liens, no fines, code enforcement violations to be a member. Members hold office are appointed by the individual council members and shall be coterminous with that council member. As you understand, that means when their time in, your time in. Appointed by the city council as a whole shall be also terminus with the mayor's term of office. Vacancies appointed by the city council and shall be remain and unexpired by the terms. Office, you have a chair, a vice chair, and a secretary. The first BOA meeting in June is when you have your elections for the chair and vice chair. Each office member is for 1 year with eligibility for re-election. The community planning and development director or designee serves as the secretary. Removal, this is important. For no cause, 3 affirmative council votes can remove any member. At the discretion of the city council, any board member with 3 absences within a year shall forfeit membership. City council may accept military services or extended illness as excused absences. And the sources of this is APA, IP planning, and things like that. Any questions?
Nope. Nope.
I do have a question. So, as a consultant, if there comes an opportunity to do maybe a training or something for the city, would that constitute employment? And I cannot be on the board? No, I need to know. I'm a
Mr. Hale.
I'm sorry, I was typing up notes for staff. Can you repeat the question?
As a consultant, since Mr. Cook says that you cannot hold any other elected office or be an employee of the city as you serve on the board. So if I work as a consultant and there's an opportunity for me to do a project with the city, so does that puts me in the violation?
I think you should ask that question outside of the context of the hearing, and
Or just give
city
them my
attorney's
free
office
time?
can
Yeah.
respond. I would hate to give you an opinion without
Okay.
looking at the exact language
Okay.
that applies and knowing more about your situation.
One more question. On your presentation, I believe it said 1-year term with a 1-year
For
extension.
the chair and vice chair.
Oh,
Chair and
that's for
vice
chair
chair.
and vice chair.
Right.
Okay, gotcha. That's it.
Um,
think we need to clarify that, because I don't think it's a 1 year, I don't think you're limited, I think you can just.
No, you have to
every time
be
they feel like
reelected.
I just,
Reelected.
I
They wanna
just
put
wanted to
their name
clarify that, didn't,
or
wasn't
person
term
in
limits on the
there.
board members.
No.
That's
That,
fine.
that runs with your individual city council
Yeah.
member, plus you, when they're termed up, you're.
Yeah, so after this election,
Yeah, then we'll have to be reappointed again.
yes.
Okay.
Yeah.
Madam Chair?
Yes,
Two
Mr.
things.
McDermott?
And this is a request to staff. I know that there's publications that are directly relate to what we do as a Board of Adjustment. Any such publications, like the Planning Commission, we're getting publications, you know, from Alta and things of that sort, as members of the Planning Commission. So any publications that, you know, that would benefit our service on the board, we'd like to receive those. I know we're gonna be receiving it from Planning Commission, so any that you determine might be helpful, for us to see what else is going on, how people are doing things, you know, that kind of thing. You know, cases, I think it'd be helpful. I'd love to see a publication or two, you know,
Give it to me, I'll
myself.
read it.
Yeah, yeah, we'll actually read it.
Whatever
Yeah.
you send. I'll read.
The other thing too is, and the first case tonight, which was in reference to a setback. I happen to know that what the architect was designing was a, quote, office with a bathroom. Okay? Now, in my term when we had the code enforcement board, I can't tell you how many times we used to have code violations coming up for offices that were converted to bedrooms. All it takes is a movement of furniture. Okay, and I think that we actually asked that there be a resolution to that effect, that if you were gonna add a room onto your house, that you couldn't add a bathroom to it. So would somebody just check that for me? I'd appreciate it. I'm just saying, I voted for it, but because it was not an item that we were, you know, that was not the issue at hand.
So in
But-
essence, if that's the case, and I want to sleep in my office,
No,
do
no,
I
no,
need to
what-
call
couch.
with
no, what
code and let them
people-
know?
No, what people were doing, no, no, what people.
Seems a little
I
overreaching.
think what Mike is saying is that you don't want it to become a rental.
A rental,
type
and
of
that's
thing.
what
But,
was happening,
and-
and we got a lot of that when we
and-
had a code
Oh.
enforcement
And in all,
board.
and if you look at the way that, you know, what they presented and where it's situated, you know, you can tell,
Well, it
there's
just
no way,
raised the
unless
point.
you're gonna go to the back, I mean, Come on.
We have an ordinance against short-term rentals, so that would fall, if that's what they decided to do with their expansion,
even
that
a
wouldn't be
short-term.
something that our, board would concern about. That would fall under some kind of code violation
No, well,
of
sometimes
use.
it's not short-term rentals, sometimes they,
No, but it's
Or
well
long-term.
presented.
Yeah.
You could look at their plan. They have a bunch of bedrooms with bathrooms there, but as a guest, if you need to go to a restroom, you have to go to a bedroom,
well, no, what,
you know,
well,
so.
no, what they were doing is the space became a bedroom with a bathroom. and
Oh,
became
no,
a
I
rental.
understand, but I'm just saying, if we're talking about that particular case tonight, you
No, no,
can
no,
look at their plans.
I'm just saying it brought up the issue of whether,
So-
of whether or not that, you know, that's something that should have been, I don't know where that would have been picked up or gone through, or
Mr. Cook,
who
I'm
would have.
sorry.
So, Mr. Medina,
Yeah.
when I look at items when they come in through the building permit and they
Yeah.
add an addition onto their home, first thing we look at, Amanda and I, is the connectivity clearly within the resident? Is it clear access from the resident, is not
Yeah.
closed off, things like that? Because that's a red flag to us to exactly what you're speaking of. And we
Right.
bring it, and to what the chairperson is speaking of, is clear the way they have articulated this, this is clearly a part of the house. It's fully integrated and access to from several ways into the main house. You have that family room that is, over there to the,
Right.
west side, I believe. Not looking at the plans that you have it. So, but your point is well taken. It's something that we are very sensitive about when we are looking at building permits, when people are adding onto it, and make sure that it's clear access and all that, and they, you know. And we even have pauses when they have a door that is accessed from that room, that we bring it to their
Right.
attention. We really pay attention to that, to try to avoid the scenario that you're speaking of.
Yeah, yeah,
Okay,
okay.
anything else? No?
Move
Okay,
to
so-
adjourn?
Oh. Do I have a second? All right, all in favor?
Aye.